There we go. Again, thank you guys for joining today. The webinar today is on qualified student loan matching contributions. Today presenting is John Nownes. As most of you know, John is the vice president and an ERISA attorney, as well as a relationship manager here in retirement plan services at UBT. And before we get into this, just a little bit of housekeeping. We will have time at the end for questions. If you do have any questions, though, please hang on to those until the end. And if you utilize the chat box, we'll definitely get to those questions as well. John's contact information is posted at the end of the webinar. And as always, feel free to reach out to your relationship manager with any follow-up questions that you might have after the fact. Today's presentation is being recorded, as you can tell, and will be included in the plan sponsor email, as well as posted to the website. So when that becomes available, we will send out some information notifying you that it is available and then where you can actually access that as well. So before I hand it over to John, I'm not going to read this disclaimer verbatim by any means, but we just want you to know that the information that John is going to provide is intended for educational purposes only. So neither John nor UBT is providing any legal, tax, or financial advice, just education this morning. And that's what this disclaimer is saying. So with that, I will hand it over to John.
Thank you, Jason, and thank you for joining us this morning as we talk about Secure 2.0's provisions that allow employers to make matching contributions on an employee's student loan payments for qualified higher education expenses. Those matching contributions can be in the form of a regular matching contribution or a safe harbor matching contribution. Now, one thing I do want to bring up that there's been some confusion among employers and actually some in the retirement plan industry. This is an optional feature. Employers are not required to adopt a student loan matching contribution feature in their plan. So if you're making matching contributions on employee elected deferrals and you don't want to make matching contributions on student loan payments, then don't adopt this feature. It's optional. However, if you are going to put a student loan matching contribution feature into your plan, then you're going to have to comply with the rules that we're going to be talking about today. So you can put this feature in a 401k plan, a 403b plan, a governmental 457b plan, or a simple IRA. So the background here is that Congress has been concerned that high student loan debt has prevented some employees from saving adequately for retirement. So if an employee is paying off student loan payments and they don't have money left over after paying student loan payments and other bills to make elective deferrals in their employer's retirement plan, then they don't have elective deferrals, and no elective deferrals means no matching contributions, and they don't have enough money at retirement. So what Secure 2.0 does is addresses this issue, again, by allowing employers to make matching contributions on student loan payments. I don't think this student loan matching contribution feature is right for all employers, but there is going to be at least some employers that find this to be a good employee recruiting and retention tool. But up to this point, employers have been reluctant to put a student loan matching contribution feature into the plan without some sort of IRS guidance fleshing out the rules with this. So the IRS issued notice 2024-63 in August, and we've seen an uptick in employers that want to at least explore putting this feature in their plan. So this feature can be put in plans anytime after January 1st, 2024. But as I said, there's been a lot of reluctance until IRS guidance. And so we got that guidance. So let's talk about the rules surrounding a student loan matching contribution feature. And the first thing we need to talk about are some key concepts before getting into the details of what this feature looks like. And the primary concept that we really need to understand is what is a qualified student loan payment. So understand what we're going to be doing here is that we're going to be making a matching contribution on an employee's student loan payment. But in order to receive a matching contribution, that student loan payment must be a qualified student loan payment, or acronym Q-slip. So for a student loan payment to be a qualified student loan payment, the loan payment must be made by the employee to repay a qualified education loan incurred by the family, or rather incurred by the employee, to pay for qualified higher education expenses for the employee, spouse, or dependent. When Secure 2.0 was passed, there was some question as to whether, for example, I'm the employee and I have student loan debt for my child or my spouse or other dependent. Can I receive a matching contribution on that student loan payment that I made for the benefit of my spouse or child, or did it have to be my student loan payment? On my own student loan, the IRS said, yes, that's fine. It does apply if the employee is making student loan payments for the education expenses for the employee's spouse or dependent. You'll see I underline that requirement that the student loan must be incurred by the employee. And what incurred by the employee means is that the employee must have a legal obligation to make the loan payment. So for example, if my son has a student loan and he's making those payments, he's obligated to make those payments, but I decide that, oh, I'll make those payments for you. And then I go to my employer and say, yep, I'm making some student loan payments for my son. I'd like a matching contribution. Well, I'm not legally obligated to make those student loan payments. My son is legally obligated to make those payments. So the fact that I'm making them, I'm not going to get a matching contribution because that's not a qualified student loan payment. It certainly is a student loan payment, but it's not a qualified student loan payment unless I'm legally obligated as the employee to make those loan payments. So if I'm, for example, a co-signer on a loan, then I have a legal obligation to make those payments. Now, if my son is the primary lender and he's making those student loan payments, then even though I've got a legal obligation to make those payments as a co-signer, the fact that he's making the payments and I'm not means that he might be able to get a matching contribution under his employer's plan, but I'm not going to be able to get a matching contribution because even though I'm legally obligated to make those student loan payments, my son and not me is making those student loan payments. A guarantor situation. My son is taking out a loan. I'm the guarantor on the loan. I don't have a legal obligation unless the primary borrower defaults. And so, again, if the loan is current and I'm a guarantor and I'm making those student loan payments, I've got a legal obligation only when the primary borrower defaults. So I'm not going to receive a matching contribution on those student loan payments because I don't have a legal obligation until the primary borrower defaults. Qualified higher education expenses, it means cost of attendance under the Higher Education Act of 1965. It's very broad: tuition, fees, books, supplies, room and board, etc. And then finally, for a student loan payment to be a Q-slip or a qualified student loan payment, specific certification requirements need to be satisfied. The next kind of key concept discussion, and there is a lot of confusion I've seen about kind of keeping straight what a Q-slip is, what an elective deferral match is, and what a Q-slip match is. So let's go through these terms, and you're going to hear me say it several times during this presentation to make sure it's cemented in everybody's head, is that a Q-slip is just the participant's student loan payment, right? I've got a student loan and I'm making student loan payments to my student loan lender. It's not some contribution being made to the plan. I'm just making my student loan payments on a monthly basis. I'm not putting anything into the plan. So it's not an elective deferral that I'm putting into the plan, and it's not an employer contribution. It is just what it sounds like. It's a student loan payment that I'm making to the lender. But if you do implement a student loan matching contribution feature in your plan, then you're going to have and kind of two types of match, but not really different types of match. What's happening is you're going to be matching two different types of dollar amounts or status. And so what I mean here is that right now, when you make an elective deferral and the employer matches that elective deferral, then we're going to call that an elective deferral match because the employer is making a matching contribution based on the participant's elective deferrals. Now, let's say we've got a student loan matching contribution feature in the plan, and I'm the participant, I make my student loan payment, I tell my employer, I made a student loan payment, I'd like a matching contribution based on that student loan payment. When the employer makes the matching contribution based on my student loan payment, we're going to have that be called a Q-slip match because we're matching the student loan payment. But we're going to see in a couple of minutes that, as I like to say, a match is a match is a match. It's going to, the only difference is that we're matching a student loan payment rather than matching a participant's elective deferral. So here's an example. Our participant makes $2,000 in qualified student loan payments, $2,000 off to the student loan lender. This is a Q-slip. It's not a contribution to the plan. Participant, a second participant, makes $3,000 in elective deferrals to the plan. The employer's matching contribution formula says it's going to be 50% on the dollar. And so our first participant is going to receive a matching contribution of $1,000 based on that participant's Q-slips. $2,000 in Q-slips made to the lender, 50% of that, a $1,000 matching contribution. And we're calling that a Q-slip matching contribution because we're matching the student loan payments of $2,000. Our second participant, remember, made $3,000 in elective deferrals. That participant will receive a $1,500 matching contribution, 50% of the $3,000. And because the elective deferrals are being matched for our second participant, we're going to call that an elective deferral matching contribution. There is a specific plan year requirement in that the Q-slip match for a plan year must be based on any Q-slips made in that same plan year. So here's an example. We're going to, our employer is going to make Q-slip matches, and we have a Q-slip match claim deadline of March 31st of the next year. And we're going to talk a little bit later about what a Q-slip match claim deadline is. But in this example, our participant makes $12,000 of Q-slips in 2025. Our participant also makes $3,000 of Q-slips from January 1st to March 31st of 2026, keeping in mind we've got this Q-slip match claim deadline of March 31st in 2026 for Q-slips made in 2025. Our employer is going to make a 2025 Q-slip match based only on the $12,000 of Q-slips that were actually made in 2025. The employer is not going to make a 2025 Q-slip match on the $3,000 of Q-slips, our student loan payments that were made in the first quarter of 2026. Now, those $3,000 of Q-slips may receive a matching contribution, a Q-slip match in 2026, but for the 2025 Q-slip match, we're only going to take into account the $12,000 of Q-slips that were actually made in 2025. Next important concept is, just like elective deferrals, there's going to be a maximum amount of Q-slips that can be eligible to receive a match under our matching contribution formula. So the maximum amount of Q slips eligible for the match can't exceed the 402G limit, reduced by the participants' elected deferrals, and we'll go over an example in a moment or so. So the question is that the maximum Q slips that can be taken into consideration for our match is the 402G limit, but what about age 50 participants or our age 60 participants that have catch-up contributions? Well, the statute does not address how catch-up contributions come into play. Now, I was expecting a technical corrections bill to come out to provide that the maximum amount of Q slips that can be eligible for a match would be the 402G limit, has increased by the catch-up contribution limits. But as we sit here today, no such technical corrections bill has been signed into law. So the recommendation, if you're going to implement a matching contribution feature in your plan, you want to cap the Q slips that are eligible for the match at the 402G limit and not take into consideration any catch-up contributions made by your age 50 or your age 60 participant. So a couple examples. Our first example, the participant has $60,000 in compensation. Participant does not make any elective deferrals to the plan. However, the participant does make $12,000 of qualified student loan payments during the year. So the maximum Q slip amount that is eligible for the match would be $12,000. The next example, we've got a catch-up situation. So we've got a 50-year-old participant has $100,000 of compensation. Participant makes $7,000 of elective deferrals for 2025. The participant also makes $20,000 of Q slips in 2025. So the 402G limit for 2025 is $23,500. And we're not going to take into consideration the additional $7,500 of age 50 catch-up contribution. So first of all, we're going to cap it at the 402G limit, the $23,500. Remember, we've got $7,000 in elective deferrals. We've got $20,000 in Q slips, and we're getting ready to apply our matching contribution. The maximum amount of Q slips that is eligible for the match is $16,500. And we get there by taking the 402G limit of $23,500 for 2025, not taking into any part of that $7,500 catch-up limit. So we're taking the 402G limit, we're subtracting the $7,000 that our participant made in elected deferrals, which means when we go to apply the matching contribution formula, the employer is going to look at the $7,000 of elective deferrals as well as $16,500 of the Q slips made by that participant. Next, if you're going to have a student loan matching contribution feature in your plan, you must make matching contributions on any student loan payments that are qualified education loans, and all qualified education loans must count toward the Q slip matching contribution. For example, you can't restrict your Q slip matching contribution program to those employees, for example, that are pursuing a Bachelor of Arts or a Juris Doctor or a Master's of Business Administration or any specific program of study. If you're going to have this in your plan, all qualified education loan payments must be matched pursuant to any caps and such like that. Also, you can't restrict the Q slip match to attendance at a particular school. So I can almost hear, but what if? And so the example is Oscar Homer has a Q slip matching contribution program and wants to make Q slip matching contributions, but to exclude any student loan payments that are made to pursue degrees at the University of Colorado or at the University of Iowa this is not permitted, they will get a Q-slip match even if they are attending school at Colorado or Iowa. So keep in mind the key concepts that we talked about earlier. We had a elective deferral match, and that's the matching contribution that's made on elective deferrals. And we've got a Q-slip match, and that's the match on student loan payments. But both matches are treated identically inside the plan. The only difference is what we're matching. We're matching student loan payments versus matching elective deferrals. And remember, elective deferrals are actually going into the plan. Student loan payments are not going into the plan. They're being paid to the lender. So we have to have the same matching rate. And we're going to talk about a little bit what that might mean in a couple of minutes. So for example, if you're making a dollar for dollar match on the first 4% of compensation deferred, then you're going to make a dollar for dollar match on the first 4% of student loan payments. So if you got somebody making $100,000, and they make $4,000 of student loan payments, they're going to get a $4,000 Q-slip match. Same eligibility rules apply. If, for example, someone is eligible to participate in the matching contribution portion of your plan immediately on their hire date, well, it doesn't matter. You're not going to have a separate rule for a Q-slip match eligibility. If they are eligible to receive an elective deferral match, they're eligible to receive a Q-slip match, and that also goes along with allocation conditions. It's not uncommon for an employer to say, you need to be employed on the last day of the plan year to receive a match. Or maybe the employer says, you don't have to be employed on the last day of the plan year to receive a match. It doesn't matter whether we're talking about elective deferral match or a Q-slip match. If you allow somebody to receive an elective deferral match without being employed on the last day of the plan year, then you can't impose a last day of the plan year employment requirement for a Q-slip match. Vesting schedule, it's the same vesting schedule. It really is a match is a match is a match. You're just matching a student loan payment rather than elective deferrals. And so it's going to be record kept on the system as a single match source. Again, the employer is just going to make a match, and it's going to go into the match source in the plan's record keeping system. So our example, 50 cents on the dollar, we're going to match deferrals and qualified student loan payments. Our deferral participant makes $4,000 of deferrals. Our qualified student loan payment participant doesn't make any deferrals, but does make $4,000 in Q-slips. Both participants will receive a $2,000 matching contribution. $4,000 multiplied by 50%. It's just that our deferral participant is going to receive an elective deferral match. Our qualified student loan payment participant is going to receive a $2,000 Q-slip match, and both of those matches are going to go into a match source. The IRS notice does a really nice job and provides us with significant flexibility on the procedures we can adopt when it comes to implementing our Q-slip matching contribution feature. And what constitutes a reasonable procedure is a facts and circumstances test. And so the good news about facts and circumstances test is that we're not necessarily hemmed in. We can adopt any reasonable procedures. The downside, of course, to any facts and circumstances test is you don't know what's reasonable, really, until the IRS audits you. Or if what we're really hoping is that the IRS is going to follow up this notice with proposed regulations, and industry groups have submitted comments and letters to the IRS, and it would really be helpful if you give us some kind of safe harbor examples of what is reasonable in some of the areas that we're going to be talking about in a bit. But I think most of us kind of understand what reasonable is and kind of understand what the IRS might get worked up about. And we'll talk about some of that in a bit. We said a bit ago that a student loan payment, to be a qualified student loan payment, must satisfy certification requirements. These are the 5 data elements that need to be satisfied through certification for a student loan payment to be a Q-slip. The first 3 data elements must have annual certification. And those first 3 data elements is the amount of any loan payments, the date of any loan payments, and the fact that the employee made those loan payments. Those 3 data elements must be certified annually before a matching contribution can be made on those student loan payments. The last 2 data elements can be certified on an annual basis, or can be subject to a one-time certification if the employee registers the loan with the plan. So the employer says, yep, you need to register your student loan with the plan, and we'll talk about that in a minute. So these last 2 data elements are that the loan is a qualified education loan, and it was used to pay for qualified higher education expenses for the employee, spouse, or dependent. And finally, that the loan was incurred by the employee. Remember, loan being incurred by the employee means that the employee has a legal obligation to make those loan payments. The IRS notice gives us a whole lot of flexibility on how we can satisfy the certification requirements. So at one end of the certification spectrum is that you can put a procedure in place to allow for affirmative employee self-certification as to any or all of the data elements. And here, basically, I think what you're doing is you're just putting a piece of paper in front of the employee, and the employee's gonna fill out some blank lines and check some boxes and said, yep, I made $1,000 student loan payment on the 5th of every month, so I made a total of $12,000 in student loan payments. Yep, I'll check that box. It's a qualified education loan. Yep, it was used for qualified higher education expenses. Yep, I'll check the box for a spouse. So that's employee self-certification as to all of those data elements. No verification is required. However, because there's real dollars at stake here, in the sense that the employer is going to make matching contributions on those Q-slips, I would imagine that most employers won't 100% take the word of employees for everything. So I suspect there will be some sort of verification or substantiation procedures put in place. But again, this is one end of the certification spectrum, is that you can make it easy on yourself and just allow an employee to self-certify as to all of those data elements. At the other end of the certification spectrum is that we're going to adopt some verification and substantiation procedures, and we're going to require our employee to provide documentation to all of the data elements. For example, we can say, yep, we're not going to make a matching contribution on any Q-slips until you provide us with things like canceled checks, loan payment statements, loan documents, and then you can receive your Q-slip match. So one end of the spectrum, pure employee self-certification. The other end of the spectrum, which is you need to prove up everything through documentation. The last 2 data elements, a couple slides back, the requirements that it's a qualified education loan to pay for higher education expenses, that the loan was incurred by the employee. Remember, I said that these last two data elements can be certified on an annual basis, or you can put a one-time certification procedure in place as long as the employer requires the employee to register the loan with the plan. And I don't think there's any magic as what it means to register the loan with the plan. It simply means that the employee is going to provide information to the plan about these last two data elements, that it's a qualified loan used to pay for education expenses, and the employee's got a legal obligation to do it. And so the employer could adopt an employee self-certification with these last two data elements on an annual basis, or the employer can develop procedures that say, I'm going to require the employee to register the loan with the plan, and I'm going to require the employee to provide me with the loan documents that say, yep, okay, you've got a legal obligation to do it, and indeed, it's a qualified education loan for higher education expenses. Boom, the loan is registered with the plan. You don't need to certify those last two data elements then on an annual basis, unless there would be a second loan or a different loan that would need to be registered. So if you go this route, then the only thing you need to do on an annual basis would be loan payment amount, loan payment date, and the fact that the employee made those payments. The IRS notice also says you can put in place an independent verification scheme that would validate accuracy of those first three data elements: loan payment amount, loan payment date, and the employee made the loan payments. And the IRS notice says, for example, the employer could put in a scheme for a procedure where loan payments are made through payroll deduction. I suspect, though, at the end of the day, that payroll is complicated enough, and most employers aren't going to be making student loan payments through payroll deductions. And in any event, the employee might not want to pay student loan payments through payroll deduction. But the IRS notice says that that can be done. Another option is kind of a combination of self-certification and passive certification. It would involve 4 steps. So the first step would be is that we have the employee register the loan with the plan, where the employee provides written information about the loan, that it's a qualified education loan to pay for higher education expenses for the employee's spouse or dependent, and that the employee had a legal obligation to make those loan payments. So boom, we do it through loan registration. We don't have to do that on an annual basis, which leaves us with the first 3 data points: loan payment amount, loan payment date, and the fact that the employee made the loan. And so we're going to handle those first 3 data elements through passive certification. So here's what's happening here. The plan, the employer, or a third-party service provider is going to reach out to the student loan lender and ask for specific information about the loan payment amount and loan payment date, and whether the employee is making those payments. It's my understanding that there's some hiccup in education law that lenders might not be able to provide information about these loans in all aspects, especially with respect to who's making those loan payments. There's been comment letters sent to the IRS to have the IRS hopefully come to some sort of agreement with Department of Education and kind of work through some of these issues. But the bottom line here is that the plan or third-party service provider is reaching out to the lender to get information about loan payments and loan payment amounts. And then what happens is that the third-party service provider or the plan is then going to send a notice to the employee that says, hey, employee, we received this information from your lender about the student loan student loan payments, and the lender told us that you made $12,000 of student loan payments during the year, $1,000 a month on the 5th of every month. Is this accurate? And so this gives the employee a chance to come back and say, no, actually, that's not accurate. I made $24,000 in student loan payments. Now, if the employee does not correct the information that was provided from the lender to the plan or third party service provider, then turned around and provided to the employee, if the employee doesn't dispute what the lender told the plan, then the plan will treat that information as being accurate. In my example, $12,000, $1,000 a month on the 5th of every month, and that's going to be the basis for our student loan match. Next, we're going to have this concept of a Q-slip match claim deadline. And here's why we need this, right? Is that when I make an elected deferral to my employer's 401k plan, it gets deducted, of course, from my paycheck, and it's all within the employer's control. The employer knows that I'm taking out $100 per paycheck to go into the plan as an elected deferral. But when I make a student loan payment, my employer, of course, has no idea that I'm making any student loan payments or what the amounts are. And so the plan is going to want to set some sort of Q-slip match claim deadline where the employee comes forward and certifies or provides documentation that says, yep, I made $12,000 in student loan payments during the year. I want a matching contribution. So what the IRS notice says, again, provides some flexibility here, is that the plan can establish a single Q-slip match claim deadline for the entire plan year. Alternatively, the plan can establish multiple Q-slip match claim deadlines throughout the plan year. For example, quarterly deadlines. In any event, any match claim deadlines that you set must be reasonable, and you need to ask yourself, do the employees, do they have a reasonable opportunity to collect and furnish claim submission documentation to get the Q-slip match? Secure 2.0, the statutory language, says that if you're going to have a single annual Q-slip match claim deadline, you must allow that deadline for up to 3 months after the end of the plan year. In other words, March 31st in a calendar year plan. The issue with that statutory language is if you have a plan that fails non-discrimination testing and that some of your highly compensated employees receive an ADP refund each year, then you know that those ADP refunds need to be made to your highly compensated employees within 2.5 months after the end of the plan year, by March 15th in a calendar year plan, to avoid a 10% excise tax. And so the question is, how do you square that 2.5-month ADP refund deadline with the Secure 2.0 statutory language that says you can have, the employee can have up to March 31st into the next year? Well, the IRS notice says that that March 31st match claim deadline in Secure 2.0 is a reasonable deadline, but you can actually establish an annual Q-slip match claim deadline that is earlier than 2.5 months, and that would be reasonable. It would have been helpful for the IRS to come out and say in their notice that, oh, and by the way, January 31st, 30 days or a 45-day deadline after the end of the plan year, that's a reasonable deadline. They did not do that. Hopefully, they'll provide us with some safe harbor deadline guidance in the proposed regulations. If you ask me, I think it's reasonable to have a 30-day or a 45-day deadline. And in fact, comment letters have been submitted to the IRS to say that this 45-day deadline would be reasonable. Q-slip match frequency. At first blush, it looks like the IRS has let us have a lot of flexibility here. And so here's what we're talking about, right? Is that let's say that we make our elective deferral match on a payroll period basis. Well, you can see that there's a little bit of a disconnect if you were going to make a Q-slip match on a pay period basis. Elective deferrals, of course, come out of paychecks on a pay period basis, but student loan payments are going to be made typically on a monthly basis. So how does that work? If you're making an elective deferral match on a pay period basis, the IRS says, hey, you can actually make an elective deferral match on a pay period basis and make your Q-slip match on something that is not a pay period basis. For example, an annual basis. That would seem, if you didn't think it through or kind of read between the lines a bit, that works out real well. But let me give you a couple of situations to really try to understand what we think the IRS is saying when they say you can make a Q-slip match on a different frequency than an elective deferral match. So here's our first situation. We're going to call it the payroll period situation. So our 401k plan measures compensation and deferrals on a payroll period basis. That means we're going to apply our matching contribution formula on a payroll period basis. So our employer matches dollar for dollar on the first 4% of compensation deferred on a payroll period basis. Our employer has 26 payroll periods during the year. We have a catch-up eligible highly compensated employee that makes $260,000 a year, $10,000 per payroll period. Our highly compensated employee wants to front load the deferrals for the year and says, I want to put $30,000 into the plan. So defers 100% of compensation for the first 3 pay periods, $10,000 for each of those payroll periods. Even though our highly compensated employee front loaded the deferrals, our highly compensated employee will only receive a matching contribution for the entire year of $1,200 because remember, our matching contribution formula is applied on a payroll period basis. So it's $10,000 of payroll period compensation multiplied by 4%, multiplied by those 3 pay periods. So here, we're applying the matching contribution formula on a payroll period basis. Contrast that with a true-up situation. This time, we're going to measure compensation and deferrals on an annual basis. In other words, our matching contribution formula applies on an annual basis. But the employer is actually going to fund the match during the planned year, each payroll period. The only difference is our match contribution formula is applied on an annual basis. So same facts, dollar for dollar and 4%, 26 payroll periods, $10,000 per payroll period, $260,000 comp during the year. Our catch-up eligible highly compensated employee again, first 3 paychecks, $10,000 goes into as elected deferrals. So total of $30,000, doesn't make any more elected deferrals for the remainder of the year. In this case, we're going to still make $400 in elective deferral matches for the first 3 pay periods of the year. So we're going to put dollars in on a pay period basis. But remember, we apply our matching contribution on an annual basis, which means at the end of the year, our highly compensated employee is going to receive a true-up matching contribution of $9,200, and we get there as follows. On an annual basis, we take $260,000 of annual compensation, multiply that by 4%, or a total annual matching contribution of $10,400. But remember, our highly compensated employee already got $1,200 of match in the first 3 pay periods of the year, so our true-up matching contribution is $9,200. So a lot of details in the first 2 situations, but we need to know, what does the IRS mean when it says you can make the Q-slip match at a different frequency than your elective deferral match? in both situations 1 and 2, our employer made the matching contributions on a pay period basis. But remember, situation number 1, we applied the matching contribution on a payroll period basis. But in situation number 2, we actually applied the matching contribution on an annual basis. We may have been making contributions or match on a payroll period basis, but we apply the formula on an annual basis. So what does the IRS mean? Can we apply a matching contribution formula for a Q-slip match on an annual basis, but we apply the elective deferral matching contribution on a payroll period basis? Or is really what the IRS saying is, you have to apply the matching contribution the same way, whether it's an elective deferral match or whether it's a Q-slip match. In other words, if you apply your matching contribution on a pay period basis for your elective deferral match, then you need to apply your matching contribution on a payroll period basis for your Q-slip match. Or is the IRS saying, yeah, you can just apply the matching contribution formula differently, depending whether it's an elective deferral match or a Q-slip match? So I think what the IRS is saying is that, I think what the IRS is saying is that if you're going to apply your elective deferral matching contribution on a pay period basis, you need to apply your Q-slip matching contribution on a pay period basis as well. And of course, I think there's a mismatch, is that you don't make student loan payments on a pay period basis. So if you are right now making your elective deferral match on a pay period basis, I'm not sure that you can put a student loan matching contribution feature into your plan, because it feels like it's a round peg in a square hole. But the IRS needs to issue proposed regulations and really flesh out what they mean by you can make the Q-slip match on a different frequency than your elective deferral match. There has been comments put into the IRS that said, hey, a lot of employers make their elective deferral match on a pay period basis. And if you want people to adopt a Q-slip matching contribution feature, you need to allow the Q-slip match to be made on an annual basis. So we'll see where the IRS comes out on that. So in closing, if you're interested in putting in a student loan matching contribution feature in your plan, you're going to have to work through a bunch of details and adopt procedures that make sense for you. For example, you need to figure out how you're going to satisfy the certification requirements. Are you going to go the pure employee self-certification route, or are you going to go 100% documentation and not take your employee's word for anything? Are you going to have loan registration with the plan? Are you going to have a third-party service provider? How are you going to handle the certification requirements? Also, what kind of Q-slip match claim deadlines are you going to have? And then finally, how are you going to noodle through that frequency of Q-slip, the frequency of making the Q-slip match? So I would encourage you, if you're interested in doing this, to talk to your Union Bank relationship manager. You can always give me a call or email me at any time if you have any questions.
So with that being said, are there any questions? I don't see anything in the chat box right now.
I was going to say, so that's the end of my prepared remarks. Does anybody have any questions at this time that I can answer?
Doesn't look like anybody does.
All right, then, like I said, feel free, there's my contact information. Email me, call me at any time if you want to talk through any of these issues, or if there's anything else you've got questions about. The IRS notice does provide information on how to conduct ADP testing. A lot of flexibility there too, but I didn't think that necessarily be appropriate for this webinar, but there's a lot of flexibility on how plans can pass non-discrimination testing for those folks, for example, that are making student loan payments but not making elective deferrals. So if you've got any questions on that or anything else, feel free to give me a call or an email.
So with that being said, thank you all very much. Like I said, this is going to be, or it has been recorded. We'll send out some information when it becomes available, letting you guys know that it is available and then where to find it. And with that being said, so thank you guys all very much for joining today, and we will talk soon.